welcome to Xavia Fox Talks, and I'm your host, of course, Xavia Fox. So now that I've gotten that out, so back to your frequently asked questions.
Another frequently asked question with respect to on the business front is when I have business owners that would come to me looking to form an entity or operate without having any type of entity formed. My advice is always to take a look at the nature of your business. If you are going to be providing a service or offering a product, it's always best to have some sort of protection in place. So you're not operating out there as a sole proprietor, meaning you don't have, and everything's under you personally. I
did that for 12 years. I was terrified.
Right. You want to make sure that you sit down with an attorney to talk about the nature of your business, what your plans are for your business in terms of growth. And if you have partners involved, if you have agreements governing the nature of your relationship with them, when that relationship ends, what contributions there are from the partners, what does sweat equity mean from people who don't contribute capital to your business. You want to make sure that you work all of that out. It's always best if you are in a partnership relationship to have that agreement set forth before you do anything. It's always a bad situation when you are friends and you end up not being friends just because you didn't hammer out the details and expectations, aren't understood.
Exactly.
Okay, so when everything's in black and white, it's a little easier to have a point of reference. Well, this is what we meant. This is what we agreed on.
This is what we agreed on.
And there can, you really can't argue with what the party signed unless there really is a misunderstanding about what certain terms mean. And it speaks to another issue. When you're working in partnership relationships, you're at the point of preparing a partnership agreement, it's always good to have outside eyes, independent counsel, to look at, making sure that your interests are protected. I've seen a lot of times where you're on a budget, you use one attorney to represent both your interests and the interests of the company. Well, that might not necessarily be a good thing. Actually, it might be a conflict there. There is a conflict there, actually, because you have certain interests, whoever your partners are, they have interests of their own, and then you have the business or the entity that, you might want counsel for that entity representing the company, and that will probably come down the line, but you want to make sure that all parties have independent counsel so there's no muddying of the waters, and that everyone understands that this is serious business. You take it seriously. You make sure everything's in writing.
So you would actually suggest for a partnership you would have 3 attorneys, one for the business specifically, and one for each individual partner.
Exactly.
Okay. Okay.
And 2, when you have investors, you may have been in business for 5 years and you have a partnership with someone. And let's say it's a corporate entity. You have an investor that comes in. They may be silent. They have no control over your business, but they have money. They have no sweat. They have skin in the game as well. So they may need an attorney representing them. You have a business that would make sure that the shareholders are protected, and then you have the managers of the business possibly that want to make sure that they're protected as well. So whenever you have varying interests, you want to make sure that you get counsel to protect you.
Let me ask you a question on that. I know of a situation where 2 people went into a business. One was providing the capital for the business, the other was sweat equity. And the person who was providing the capital initially came into the business with no knowledge of the business. The person who had the sweat equity knew the business and was the one doing all the work, basically. The other was just funding. Once the person putting in the sweat equity kind of got the business formed and made the other person more knowledgeable of what actually was going on, created all the marketing materials and of that nature, the person with the capital took that information and went and started another identical business.
In that situation, it's again going back to the agreement that you had between the parties. So if you have a partnership relationship, there shouldn't be any outside conflict. So no information that's within the nature of the business should be used for outside purposes. Confidentiality agreements, non-compete agreements, all of that needs to be a part of that partnership agreement. Or if you have a corporation, that should be a part of your bylaws. LLCs, that should be a part of your operating agreement. Making sure that no partners, no members, no officers of the, nobody on the board of directors has conflicting or outside interests that might, go against the policy of the organization.
So they should have also signed a non-compete. So the business partners need to have a non-compete so that they don't duplicate business.
Correct.
Okay. All right. Okay, continue with your facts. I like it.
In terms of the asset protection side, making sure that you understand what a will is to protect your assets after you pass away. I've had clients to ask on a number of occasions, how do I, if I don't have much, should I have a will? And I advise always that you should have something in place because you don't know what you might accumulate over time, but once you're gone, it's too late. And then it's a matter of the courts determining what happens based on the statutes. So you want to at least have something in place and making sure that document mirrors what the statute will qualify as a will. A will is sometimes not even enough because the will be in place, but you still need to go through the probate process to have the court approve that document.
Oh, really?
Land trusts are an option. If you have real estate and the property is in a land trust, if you should pass away, we will pass away, the property that's in the land trust will automatically transfer to whoever you designate without having to go through the probate process.
Oh.
So that's one way of sidestepping or cutting out the middleman, so to speak, and making sure that things happen in accordance with the way you intend. Now that's only for real estate and land trusts operate. Living trusts are for all types of property, interest in businesses, real estate, money that might be in bank accounts, interest in insurance policies, what have you. So a living trust would be that wide-ranging document that would govern or dictate how you want your assets to transfer after you pass. And actually it can operate as long as there's stuff in the trust. Meaning if there are assets there, it will be living until those assets are transferred for whatever you dictate.
So now I'm going to ask one of those questions that I know somebody's probably thinking. I'm an only child. Do my parents really need a will? I mean, it's just going to all come to me, right?
Not necessarily. Not
Well,
necessarily.
Who's going to go to?
There might be a child that just pops up.
Well, listen, they're like 80.
Well, I mean, you can have
If something pops up now.
You can have someone to contest it and say that I am I'm your sister, and you long lost sister that you never knew about. One way to protect in that situation, if there are probate costs that will still apply if there's no will. Okay, if there is a will, there are going to be probate costs. If there is real estate, I just mentioned the land trust would be the way to have the property transferred to you automatically in the event of your parents' death.
Okay.
If there's a living trust, assets in that trust will transfer to whoever they designate automatically without having to go through any probate. So just not having a will, it's not a good thing, but it's not enough. Having a will is not enough to keep you out of court, probate court. In the event
I guess that's what everybody thinks too. If you have a will, you just assume that you go to the reading of the will, and that's the way it is on the movies. They say, "Oh, you're going to get this." It's like, that's not how it works, though.
Yeah, that's not how it works.
Okay.
All the time. You do have a reading, but there are things that happen after that.
Okay. On my page, there are a lot of promoters. Event promoters, I don't want to say club promoters, but a lot of event promoters and people starting clubs and things of that nature. I have a lot of authors. So what are some of the legal suggestions that you give to them?
Well, for promoters, you want to make sure you have ironclad agreements with what the location that you're promoting an event, making sure that you have an agreement as to what happens with door monies, what's happening at the bar, who collects from those monies. If you're going to be selling items, those vendors, if there's any agreement with respect to the type of items that can be sold, you want to make sure that there's appropriate licensing in place for the establishment that you're going to be using for your event, and that you have appropriate licensing to promote and do what you're doing. Your business needs to be licensed as well in certain areas and capacities. So just making sure that all I's are dotted and T's are crossed. If you're going to have minors and there's liquor at the establishment, you want to make sure that you have protections in place and understand what the ramifications might be if that minor got hold of alcohol, left the establishment, and ended up in a serious accident.
Oh, yeah, and there.
And get an attorney before you have the event. You don't want to, don't want to run into the situation where you're not protected, and you're dealing with something after the fact. So whatever preventative measures you can take on the forefront and being proactive is always the best case scenario. Anyone that might be interested in retaining my services can contact me online, newentertainment.nu, and that's new spelled N-U, entertainment.nu. Phone number is 312-212-4416. We are located in the downtown area here at 1 South Dearborn Street in Chicago.
That's excellent. And if you want to drop any questions on the fan page for Shara, she'll be checking that as well. The fan page is Xbox Talks, so you can drop any questions for her there. But definitely, this has been a great conversation. We couldn't get Judge Mathis, but I think she's a lot cuter. What do you think?
Thank you.
Well, thank you for spending this time with us, and I'm looking forward to doing Ask the Attorney when we really get some real questions.
Yeah, I look forward to it.